Welcome to today's Explainer. We've got a really fascinating one for you today. We're unpacking a truly dramatic legal battle that literally shifted the entire landscape of workplace rights in South Africa. We're looking at a landmark judgment from the Constitutional Court, the case of NEHAW versus the University of Cape Town. At its core, this whole thing is a massive clash of interests. On one hand, you have a corporation's relentless drive for efficiency and restructuring. But on the other hand, you have the very fundamental human need for job security. So how exactly does the law balance those two seemingly opposite forces when a business changes hands? Well, that's exactly what we're going to explore today. Here's a quick roadmap for this explainer so you know exactly where we're headed. 1. The UCT outsourcing crisis. 2. Chaos in the courts. 3. Defining fair labor practices. 4. Decoding Section 197. And finally, 5. The final verdict. All right, let's jump right into Section 1, the UCT outsourcing crisis. So let's travel back to 1997 and set the scene at the University of Cape Town. 267. I want you to just hold that number in your head for a second. That is the exact number of workers at UCT, specifically the folks handling non-core stuff like cleaning, gardening, and maintaining the sports grounds, who just abruptly found themselves losing their jobs. The university had decided they were going to outsource these services to 4 separate private contractors. Just imagine being one of those 267 people, right? One day, you're securely employed by a major, prestigious university, and literally the next day, you're handed a retrenchment notice simply because your role is being handed off to an outside company. Now, to be fair, UCD didn't leave them completely in the dark. They told the workers they couldn't just automatically transfer over, but they did invite them to formally apply for new jobs with these incoming contractors. But man, here is the devastating catch. While most of the workers applied and a majority actually were accepted, those who got rehired faced a really grim reality. They were taken on under conditions that were significantly worse than what they had at UCD. Crucially, they were getting paid far less. They lost all that security and the benefits they'd spent years building up. It was effectively like starting completely from scratch, but at a massive discount. Which naturally leads us to Section 2, chaos in the courts. As you can probably guess, the workers and their union, NEHAW, were absolutely not going to take this lying down. They fought back hard to get those original contracts honored. And this wasn't some quick fix. It turned into this grueling, multi-year legal marathon. It started out with an urgent application in the labor court. When that failed, NEHAW appealed to the labor appeal court. And then, when the majority there ruled against them too, the union escalated the whole fight all the way to South Africa's highest court, the Constitutional Court. That's what finally gave us this 2002 judgment we're looking at today. It really just shows you how fiercely contested these labor laws get when you have massive financial and personal stakes on the line. So the majority in the labor appeal court ruled against the workers, and they used some incredibly vivid, honestly kind of wild imagery to justify their decision. They stated, quote, "To say that there can be a sale of a business as a going concern without all or most of the employees going over is to equate a bleached skeleton with a vibrant horse." Essentially, their argument was that a business couldn't possibly be transferred as a going concern unless the old boss and the new boss explicitly agreed in advance to take the workforce along with them. Without the workers, they argued, you're just selling the bleached skeleton of a business. If we break down what those lower courts were actually thinking, you see a very distinct legal philosophy at play. They looked at the relevant law, Section 197, and decided it absolutely required a prior agreement between the buyer and the seller. If the two companies didn't shake hands on moving the workers didn't move. Simple as that. This perspective obviously leaned heavily toward protecting the employer's flexibility to structure a corporate sale however they wanted. It basically treated these business transfers as asset-only sales, just moving mops, buckets, and client lists. But the human cost of that logic was massive. It left our 267 workers completely stranded and totally stripped of their original job security. And that brings us to Section 3, defining fair labor practices. This is where the Constitutional Court, led by Justice Ngobo, finally steps in. But before they could even dive into the specific labor statutes, they had to address the absolute bedrock of South African labor law, Section 23 of the Constitution. That's the section that guarantees everyone the right to fair labor practices. Now, the union tried to argue that this right was strictly for workers, but Justice Ngobo sharply disagreed. He pointed out that fairness is not a one-way street. The court defined fair labor practices as an equitable relationship that has to accommodate the interests of both the workers and the employers.
It's a delicate balancing act, right? You have to weigh the employer's genuine need for profitability and efficiency against the worker's fundamental need for job security.
With that constitutional foundation set, the court went right after that whole bleached skeleton metaphor by clearly defining what a going concern actually is. The Constitutional Court completely dismantled the lower court's logic. They said, look, a going concern is simply a business in operation that is transferred so that it remains the exact same entity, just operating in different hands. And here's the real kicker. Determining if a business is a going concern is based entirely on objective facts. Are they doing the same work? Are they using the same assets? Are they servicing the same clients? It absolutely does not depend on some prior backroom agreement between corporate bosses to take on the workers.
Let's move on to Section 4, decoding Section 197.
Okay, so now we get to the specific piece of legislation that was the ultimate battleground for this entire crisis, Section 197 of the Labor Relations Act. To truly understand why Section 197 exists in the first place, we have to look at the pretty brutal reality of the old common law. Back in the day, if a business was sold, it almost always meant instant job loss. The new owner was under zero obligation to keep the old workers, none. This led to massive retrenchments, it forced old employers to pay out huge severance packages, and it just created a generally chaotic environment that honestly made it harder to do business. Section 197 was drafted specifically as an exception to that old common law to fix this exact mess. It ensures that when a business is transferred as a going concern, the workers' contracts automatically transfer right along with it.
And this leads us to what is frankly the genius of Justice Nkobo's interpretation. He identified that Section 197 actually has a dual purpose. It is not a zero-sum game between capital and labor. On one side, yes, it is fiercely protective of workers, preventing those unfair job losses when a company changes hands. But simultaneously, it actually facilitates business. Think about it. By automatically transferring the workforce, it relieves the old employer of massive retrenchment costs, and it allows the new employer to immediately take over a fully functioning, highly experienced workforce on day one. It's literally designed to help business transactions flow smoothly while simultaneously saving jobs.
So, how does this actually work in practice? Let's walk through the mechanics of Section 197, according to this judgment. Step 1. A business, or even just a part of a business, like a cleaning service, is transferred as a going concern. If that objective fact is true, Step 2 triggers immediately. The continuity of those workers' employment is preserved by law. And then Step 3, the new employer is automatically substituted into the original employment contract. They effectively step right into the old employer's shoes. The new employer inherits all the rights, the obligations, and, most importantly for the workers, the original pay grades and benefits that they had from day one. Which brings us to Section 5, the final verdict. We've seen the crisis, we've seen the chaos in the lower courts, and we've unpacked the Constitutional Court's brilliant legal decoding. Now for the climax of our explainer. The definitive ruling from Justice Nkobo was crystal clear. Workers transfer automatically by operation of law. A prior agreement between UCT and the new contractors was absolutely not required to protect that workforce. If an employer outsources a service and it objectively qualifies as transferring a going concern, the law steps in and it shields those workers. Employers simply cannot draft a sneaky contract that intentionally leaves the workers behind just to save a few bucks. The law simply won't allow it. The tangible, real-world results of this verdict were just massive. Nahawu, fighting for the workers, had their appeal completely upheld by the highest court in the land. And in a move that really fundamentally shifted workplace power dynamics, UCT and the contractors Supercare weren't just told they were wrong, they were actually ordered to pay the legal costs of the dispute, which even included the costs for 2 legal counsel. It was a huge validation of workers' rights and a very stark warning to any corporations trying to use outsourcing as a loophole to slash wages. Which brings us to a final thought for you to chew on. The Nehawus versus UCT case isn't just some dusty history lesson from 2002. It is quite literally the bedrock of modern job security during corporate restructuring. So ask yourself, if your company was sold, or if your department was suddenly outsourced tomorrow, just how secure is your contract? Thanks to this dual-purpose interpretation of fair labor practices, you might actually have vastly more protection than you think. Thank you so much for joining me for this explainer. Keep learning, keep questioning, and I'll catch you in the next one.